I lied. This isn't a past case, but one I took last week after Gina fired her
Wait, are
previous
there
lawyer.
law students there?
Sunday, I walked into
no.
his office when I just screamed real loud.
Oh no.
Arthur was standing
Oh my
there
God.
behind the door.
You can't have law students at a witness interview. It breaks the attorney-client privilege. That's just screaming malpractice. Hey Legal Eagles, D. James Stone here teaching you how to think like a lawyer. Today we are covering the highly requested How to Get Away with Murder episode 1. Apparently you guys want to get away with a whole bunch of homicides. Well, I'll do what I can to help. Now be sure to like and subscribe to make sure you never miss out on a future Lawyer Reacts. And of course, be sure to comment in the form of an objection. If you object, I will be sure to sustain or overrule your objection. And of course, stick around until the end when I give How to Get Away with Murder a grade for legal realism. So, without further ado, let's dig into How to Get Away with Murder, Episode 1. All right, so clearly the first day of class, law school. All right, so what we're seeing here is a very large first-year classroom in law school. Generally, the classrooms aren't this big. In law school, even your first-year classes tend to be less than 50 people. Often they're 30 people or so, mainly because first-year classes are almost always graded as an issue-spotting essay exam. So you would rarely see a class that was this big, especially in a first-year class.
I threw up 4 times this morning, worried she's gonna call
she's a
me.
ball buster, sure. But I spent my summer interning for Chief Justice Roberts.
What?
Dershowitz has the upper hand in the academic world, but Keating's clearly the better defense attorney.
Okay, so there is some truth to the fact that in law school, you're going to run up against what are called gunners. Gunners are those people that just seem to have every answer to every question, and they're gonna raise their hand at every single opportunity, and they think that they have a really impressive resume. And you're gonna get people that are tooting their own horn. Now, the kind of things that these potential students are talking about is kind of ridiculous. You would never, ever have someone who is just starting law school and yet they were interning for the Chief Justice of the United States Supreme Court. It's impossible, literally impossible. And either he is a huge liar or the show just hasn't done its research. Now, clerking for the Supreme Court is something that actually happens, but you have to graduate from law school before you can ever do that. You would never be able to intern for the Supreme Court, let alone the Chief Justice of the Supreme Court, before you have gotten to law school. That's totally ridiculous.
Unlike many of my colleagues, I will not be teaching you how to study the law or theorize about it, but rather how to practice it in a courtroom.
Okay, in general, I kind of like that idea about instead of focusing on the theory of law, focusing on the on-the-ground tactics that you would use as an attorney. But these students are first semester law students. They don't know anything about the law. So generally that's why law professors will ease into the curriculum by talking about the theories and the policy arguments that undergird our entire legal system. You gotta give them a little background first before you dig into the nuts and bolts of actually practicing, because those are two very different things.
Now to our first case study, the aspirin assassin. Tell us the facts.
All right, this appears to be an actual case that may be ongoing. Law school does actually use the case method. When you're talking about cases in law school, what you're really talking about are appellate opinions. In other words, the losing party in the court below, the trial court, didn't like the way that they lost, and so they appealed that decision to the higher court to review the aspects of the law that were applied. You're not talking about relitigating the entire case. The facts are given to you. When you get to an appellate court, the evidence is set, and really you're just applying the facts as given to the law or the theory of the law in the appellate court. So it would be very weird to start out law school without any of the precedent whatsoever, without really knowing what the law is and diving into the facts of the case. So far, right now, what's happening is very unrealistic, and it's not really doing these students any favors.
Day 1 and you're unprepared?
No. Well, yes, but I didn't know there was anything to prepare.
I emailed the assignment to the entire class 2 days ago.
Oh, I didn't get that.
I don't know why this is always a trope in law school movies and TV shows. Yes, there is substantive information that is discussed on day one of class, but professors know that a lot of students aren't going to know that, and some are going to be unprepared. So they will help the student out on day one of class, if not on further days.
Let me help you out. Actus reus means guilty act, the poisoning of Mr. Kaufman with an aspirin, whereas mens rea means guilty mind.
Yeah,
so what
more or less.
Stowski's mens rea?
So the answer that she's looking for here is, what is the mens rea required to be guilty of the crime of murder, or I guess attempted murder because the guy was resuscitated? Well, the answer depends on what jurisdiction you're in. Every state has a different mental requirement for what will make you guilty of a given crime. If we're talking about first-year law students, we're probably talking about the Model Penal Code, which is adopted in many states, but not all. The Model Penal Code has several mental states that will allow you to be guilty of the crime of murder or attempted homicide. One is being intentional, another is knowing, and a third is reckless, and it depends on which particular brand of homicide you're talking about. If you're talking about intentional or knowing conduct, what you mean is that you either intended the actual outcome, in other words, the death of the individual, or two, you acted in a way knowing that that outcome was likely to occur. Those are the kind of mental states that will make you guilty. In other words, have the mens rea of the crime of homicide or an attempted homicide. So that's what she's looking for.
Think, Mr. Gibbons. It's nothing more than common sense.
To kill.
Will the individual who just spoke please stand and repeat the answer?
Yeah, but this is the first day of class, and this is the stuff that you are supposed to be teaching them. And by the way, this stuff almost never comes up in actual practice because it's all part of the theory, the philosophical underpinnings of criminal law. It is not the kind of stuff that you're going to be dealing with on an everyday basis. You would never talk to the jury about actus reus or the mens rea of a crime. You would give them jury instructions that lay out in great detail what those things mean in lay words, not in the highfalutin language of lawyers. This is not talking about criminal law from the perspective of a practicing lawyer.
Mr. Walsh.
I noticed that the verdict wasn't listed here, so I guess my question is, did she do it?
Why don't you ask her yourself?
This is so ridiculous. This professor hasn't taught them anything, and she was going to move on after she explained anything about the case except for the facts. For any given case to have any kind of educational value, you need to know what the dispositive facts are, but you also need to know what the outcome of that case is. Was the person guilty of murder or were they not? And on top of that, where did they get this information? In law school, you use case books. You don't use just random pieces of paper that contain a story about what this case was. So far, this professor has not only taught them nothing, but really wasted their time for 15 minutes, if not more.
I lied. This isn't a past case, but one I took last week after Gina fired her.
Wait, are there law students there?
Sunday, I walked into his office when I just screamed real loud.
Oh no. Oh my God. You can't have law students at a witness interview. It breaks the attorney-client privilege. That's just screaming malpractice. You may have heard that attorneys and clients have what's called the attorney-client privilege, which means that what you say to your attorney is privileged and can't be disclosed to another third party, despite them wanting to know that information. But the way you break that privilege is you have that conversation in a place where you have no expectation of privacy, or there is a third party there which breaks the privilege. And guess what? Her entire law class are not members of her firm, and they are not the attorneys for this individual. So by having literally hundreds of people present for when this person is talking, that breaks the privilege, and anything that she is saying right now can be used against her. It's discoverable, and it may be admissible in court. So this is malpractice to have hundreds of people witnessing what this poor defendant is saying. This is awful. This is sanctionable, and she should be disbarred immediately. Crazy.
Each of you have 1 minute to present the best defense for this case. See if you can beat my current plan.
What?
Mr. Gibbons,
Yes?
you'll go last. An unenviable position, seeing that no two students will be allowed to present the same idea. Use the resources in this office, Gina's discovery file, my library, the people who know me even better than myself, my associates.
Okay, that's crazy for a number of different reasons. Number one, if you're going to trial in 2 days, then you better have your theory of the case locked down. And I don't know why you're doing fact discovery, 2 days before the trial goes on. You need to have your facts in a row, let alone your entire defense theory. That needs to be ready to go. Now, on top of that, I know it sounds cute to have a bunch of law students give their theory of their best defense, but again, all of that information is discoverable. The prosecutor can get the information that these students have provided because they're not bound by attorney-client privilege or the work product privilege. They're not attorneys, they're not members of the firm, and it's... I don't even know what to say. This is so insane and such malpractice that I need a break. I need a break. This is crazy. All right, we're back. I'm not going to let this stupid TV show break me, despite the stupid legal things that are going on. We're going to plow through it. We're going to keep going.
Step 1, discredit the witnesses. Step 2, introduce a new suspect. That person is Mr. Kaufman's jealous business partner, Lionel Bryant. Step 3, we bury the evidence.
There's a very good reason you won't find any of the information that she's talking about in any first-year class in the entire country. It's because she's really doing a disservice to these students. They're not learning anything about criminal law. They're not learning about what constitutes a crime. They're not learning about the philosophy of the American legal system. She's just getting into trial tactics, which there's a time for that, but it's not when you're a first-year law student.
Why are you here?
It can wait.
Frank, you didn't lock up again. Speak.
I came across this case, Commonwealth v. McGinnis, which says we can move for a faster verdict if we think the prosecution's evidence is insufficient.
What you're suggesting is called a directed verdict. If we ask for it and get denied, all the public will hear is there's enough evidence to convict.
But you discredited the first assistant today, and
You had an idea. I'm telling you it's a bad one.
Yeah, that is a bad idea. First of all, it's silly that he learned about a directed verdict from a case. A directed verdict is a real thing, and it does allow you to get a case dismissed very early on in the case. However, that's a product of statute. So basically every jurisdiction has a statute that says you can, at a certain time, move for a directed verdict. He would know that if this teacher had taught him anything in class, but obviously she hasn't. But the time for a directed verdict is at the close of the prosecution's case. They can't just call one witness and have a good cross-examination of the prosecution's witness and say, oh, well, therefore, because this witness didn't do a good job, that we have to throw out the prosecution's entire case. That's really silly. Instead, you would wait for the prosecution to make their entire case, call all their witnesses, submit all their evidence, and then you would make a motion to the judge and say, taking the prosecution's case at face value, they haven't met their burden and established guilt beyond a reasonable doubt. That is a motion you could make, but it's only after everything has come in, not just one particular witness. So I don't know why this guy thinks he's found the secret to this case. It's a bad idea, but it's a product of the fact that he hasn't learned anything from this law professor who's the one who's supposed to be teaching. It's bad.
How'd you get this?
It wasn't exactly legal, is the point.
And we just have to get creative.
Bonnie? Mr. Bryant, you and your business partner, Mr. Kaufman, had a meeting in his office on the morning of the accident, correct?
Yes, to discuss moving Gina to accounting.
So to avoid any possible sexual harassment lawsuit?
That's correct.
Will you please read this email that you wrote to Mr. Kaufman?
Dear Arthur.
Okay, you can't just go up to a witness and ask them to read an email that they wrote. You have to establish the proper foundation. And this probably isn't interesting to anyone except fellow lawyers, but getting documents into evidence is probably one of the things that takes up most of our time in trial. And all of those are considered documents that are usually considered hearsay. So in order to get those documents into evidence, you have to, number one, lay the foundation, and number two, establish a hearsay exception or a reason why it's not hearsay in order to get that into evidence above the objection of what the other side is going to do. Now, the thing that we use most of the time is what's called the business records exception, which is a hearsay exception in most jurisdictions, and it allows you to establish that a record kept in the regular course of business is verifiable enough that it should come into evidence. But there are a lot of different elements that you have to establish in order to get that information into trial. They haven't done any of that, so you can't just go up, especially when the email is attained illegally. They're going to have some big problems in establishing that that email is what it purports to be and should come into evidence.
Your Honor, this email was not part of the discovery file.
Is this true? I thought it was. Although my associate is more familiar with the paperwork on this case. Bonnie?
Oh my God.
I found the email in the files given to us by our client's previous attorney, Your Honor. I just assumed it was part of the discovery file.
It wasn't, which means it was obviously obtained illegally.
Enough. Did you write this email, Mr. Bryant?
Yes.
Then I have to side with the defense here. The email's admissible.
Your Honor.
I've made my decision, Mr. Williams.
Now, there's a bigger problem in that the state hasn't turned over exculpatory evidence to the defense. And under Supreme Court precedent, under the Brady case, that is a constitutional violation to not give exculpatory evidence to the defense. The prosecution, if they have certain evidence that is exculpatory towards the defendant, they have a duty to turn that over to the defendants. That they haven't done so might be grounds for a mistrial, or it might be grounds for reversal if there was a conviction. They may have overplayed their hand by using this in court instead of using it on appeal to overturn the conviction, if that is where it was going to go.
As stated in the email, you were angry at Mr. Kaufman for taking part in a sexual relationship with an employee.
I was frustrated, yes.
So frustrated that perhaps you swapped his blood pressure pill for an aspirin in order to gain sole ownership of the company.
Objection!
Withdrawn. No further questions.
I hate it when lawyers on TV ask a question and then immediately withdraw it. What that means is that none of that information can come in, and you can make good points and you can hammer that point home without asking an argumentative question that's just going to be stricken immediately. It would be better to get the underlying evidence out and have that remain as part of the court's record than it would be to ask a stupid question and then have it withdrawn immediately. I hate it when lawyers do that.
The night before the murder attempt, Ms. Sadowski bought... What does it say on that label, Detective Gill?
Zaloxacor. It's a brand of aspirin.
You had one job, to let us know what bodies we needed to bury. Text calls, anything we needed to destroy, and you didn't. So guess what? Guess what? You go to jail, and I'm the shoddy lawyer who put you there. I had a headache. Stop.
I mean, it is important for clients to tell you all the bad information so you can plan around that. But I think the number of clients I've had that have told me 100% of every story is probably close to zero, and I suspect most other attorneys have to deal with clients that aren't always going to tell them everything about every single case. That's just part of the nature of the job. So her reaction as if she's never had a client who didn't tell her about a single fact before, it's just silly. And besides, her last attorney was fired. So what's to say that she's not going to fire Viola Davis's firm from this? I mean, you don't talk to a client that way, even when they've done something that's not particularly good for them.
Detective, in your 12 years working for the city of Philadelphia, have you ever known them to alter video footage to help the prosecution get a conviction?
Objection.
Digitally altering aspirin labels, for example?
Your Honor.
I'm simply asking Detective Lahey about his personal experience within his department.
This is the last question I'll allow.
Look, it's very clear whether this information is relevant or not, or whether it is admissible or not. So for the judge to allow one more question is ridiculous. I would think that this line of questioning as to whether some unnamed police officer has doctored evidence in a different case is highly prejudicial and is really minimally relevant to this case at hand. She can ask about the particular tape all day long, but for her to ask about speculation about what may or may not have happened in other cases is exactly the kind of prejudicial evidence that shouldn't be coming in, and the judge should not have allowed this evidence. It's ridiculous.
Miss Sadowski is and always has been innocent. And I'm so happy the jury agreed.
I want to be her.
Now it's time to find out who will be joining us in our firm. First, the standout in the class.
All right. Firms don't make hiring decisions based on a few weeks of the first semester of law school. In reality, what happens is you go through your entire first year, you then get a summer job in between your 1L year and your 2L year. Then when you come back to your 2L year, you will interview with a bunch of firms to hopefully get a summer associate job in your 2L summer. I mean, these students haven't had a chance to study, let alone take a final exam, and nobody knows whether they're capable of being in a law firm or not. This is totally crazy. This is halfway through their first semester in law school. This is ridiculous. Ah!
So that detective...
It's my boyfriend. Yes.
I don't want the job. Not if you pick me because of that.
That?
You got him to lie on the stand.
Is that why I picked you? Because I thought I picked you because your self-defense argument showed you think well on your feet. But we won because I did my job. You think carefully. Everything after this moment will not only determine your career, but life. You can spend it in a corporate office drafting contracts and hitting on chubby paralegals before finally putting a gun in your mouth. Or you can join my firm and become someone you actually like.
Oh my God. This law firm would not be the only law firm that is interested in the students of this law school. It's ridiculous to think that these students are going to make anything of themselves unless they work for the law firm where this law professor happens to be a partner. This is so stupid. So stupid.
So decide, do you want the job or not?
No, run away. Run away. All right, that was the first episode of How to Get Away with Murder.
All rise.
Oh man, that was rough. That was really rough. I mean, between law school scenes that were kind of like Legally Blonde, but much, much worse, and courtroom scenes that were like Perry Mason, but even more unrealistic, that was a hard one to get through as an actual practicing attorney. So all in all, I give How to Get Away with Murder, episode 1, a D+ at best. You would have flunked my class in law school. So if you enjoyed this episode, hopefully more than I did, check out this playlist I put together. It includes all my prior reactions, including to Suits and The Good Wife. So click on this playlist and I'll see you in court.